Hi, you're listening to the Lawyer Society Legal Podcast for lawyers, practicing advocates, law students, and judicial exam aspirants. In today's episode, I thought we should be talking about an interesting topic in criminal law, which is case and a cross case, also called as a case encounter. I picked up this topic because right now there is a case pending before the Madras High Court, and Hon'ble Justice Anand Venkatesh sir has posted the matter on 21st of March for final hearing. Let me just brief the scenario here. So essentially, a case and case encounter comes up when two parties involved in the same transaction allege that it is the other party that has committed the offense. So suppose A says that B has committed an offense against A, but B says that A committed the offense against B and it falls under the same transaction. Then in such cases, they are literally giving two opposite versions of the same incident. So in such scenarios, the police can register a FIR as per both the versions. Now in the state of Tamil Nadu, there is a police standing order, which is a form of rules that is issued by the state government in order to guide the police force in how they should be implementing the Code of Criminal Procedure and other criminal laws. As per Police Standing Order paragraph 566 as it stands today, a police officer cannot file a charge sheet in both cases. He has to find out who the real aggressor is in a specific case and case encounter scenario, and he has to proceed only in one matter, or he has to refer both of them, which means he has to be closing both of them. And in case he is not able to figure out who the real aggressor is, then he should be consulting the concerned public prosecutor of the district, which is the Sessions Court PP. Now when he consults the PP of the Sessions Court, such PP must be giving his opinion as to who he thinks is the actual aggressor in that matter. So if the police concludes that B is the aggressor, then they should be proceeding against B and closing the matter against A. And if the police is not able to come to a conclusion and the PP says that A is the aggressor and B is not the aggressor, then they should be proceeding against A and not B. But this particular PSO is not in line with the Supreme Court's judgment in the case of Nathilal versus State of Uttar Pradesh, which was rendered in the year 1988. The citations will be left below in the description box for you to peruse. Also subsequently, this judgment of the Supreme Court in Nathilal was reiterated and approved by another division bench of the Honorable Supreme Court in the case of Sudhir versus State of Madhya Pradesh. Subsequently, it was again approved and affirmed by another division bench of the Honorable Supreme Court. Now this was in the case of Mishrilal versus State of Madhya Pradesh. As per the judgment of the Supreme Court in the case of Nathilal versus State of Uttar Pradesh, when there are two different charge sheets filed in a case and case encounter scenario, the court can try both the cases. The same judge has to hear both the cases. He has to first hear one matter, reserve the judgment in the same, and then he has to proceed with hearing the next matter, that is the case encounter. After he hears both the matters, he has to reserve judgments and pronounce them independently. Now the evidence recorded in one matter cannot be used as an evidence in the next matter. He has to start afresh with respect to the evidence part of it. So these were the guidelines given by the Nathilal judgment, which was approved by the Honorable Supreme Court in the other two cases which I said earlier. So in the case of Sudhir versus State of Madhya Pradesh, the Honorable Supreme Court gave more guidelines with regards to what would happen if one of the two cases was exclusively triable by a court of sessions. In such cases, it was said that the magistrate should be committing the other case also to a court of sessions so that both of them are tried by a court of sessions. So this scenario is what was established by the Supreme Court, but the PSO in the state of Tamil Nadu and a few other states also have such a police standing order, is not in line with the Honorable Supreme Court's directions. So this was pointed out by several recent judgments of the Honorable Madras High Court, and we have recently taken note of the fact that two charge sheets can be filed in a case and case encounter scenario, and the PSO, that is the Police Standing Order 566, is not mandatory. Despite that being the final established law of late, Hon'ble Justice Anand Venkatesh sir has stated or has put forth this issue that the police are filing charge sheets in both cases even if it is not so required. That is, even if the police can easily figure out who the aggressor is, they are simply forwarding two charge sheets before the magistrate, which is causing a lot of trouble because it is not practically possible for the magistrate or in case it's a sessions court trial, for the court to conduct trial in both cases. Hence, it obviously causes more pending cases if the police inevitably they are going to file 2 charge sheets for every time there is a case encounter scenario. I've also written a very detailed article regarding this long time back, and in the article I had given a conclusion that PSO 566 has to be amended in a certain way so as to clarify the complete procedure and ensure that it is up to date with the Supreme Court directions. I wanted to talk about what Hon'ble Justice Anand Venkatesh could propose as a guideline to be followed by the police in the state of Tamil Nadu in such scenarios. So basically, when the police investigates into a case encounter, and if they are filing charge sheets in both matters, they should be explaining why they weren't able to figure out who the real aggressor is. And the magistrate must be given the discretion to apply his mind and figure out who the real aggressor is. And even if the police has filed a charge sheet in both matters, he must be able to negate one of it and take cognizance of the other and proceed with trying that case. And obviously, if he is going to negate one charge sheet, the particular informant in that matter has to be given the option of protesting against it. So in such scenarios, the informant in such case can file a protest petition and say that the other person is the aggressor. So that right will always be available to the informant. So if the magistrate applies his mind, he himself can figure out who the aggressor is. And if the police says he is closing case against A but he's filing a charge sheet against B, he has to provide reasons as to why he concluded that B or A is the aggressor, as the case may be. So now the magistrate has to listen to such reasons. He has to apply his mind and come to his own independent conclusion whether the police is right. And if he feels he wants to proceed against both of them, he can. Or if he wants to proceed against the other person against whom the police has filed a negative police report, he can. So the magistrate must be given the discretion to apply his mind here, which he always has. The magistrate always has discretion, but a specific direction to that effect must be made here, that the police must be giving proper reasons as to why they are not willing to proceed against one person, or they are willing to proceed against both persons and they are not able to figure out who the real aggressor is. Only if the police gives such reasons, the magistrate can go through such reasons, and the magistrate must be coming to his own conclusions, and he has to reason out his conclusions so that in case the informant in one of the 2 cases wants to go and file a revision petition or an appeal or a quash petition, a reasoned order from the magistrate would help the court going through the revision petition or hearing the appeal or quash petition, whatever the case is. So in very petty cases, the police are filing 2 charge sheets, which will obviously burden the courts with numerous case encounters. Having to try both the cases is a huge issue, and I hope Hon'ble Justice Anand Venkatesh sir figures out a very practical solution to this menace, and we have a proper solution to this. If you like this episode, please do follow us on Spotify. Also, do consider subscribing to our monthly digital law magazine. If you're interested in subscribing to our digital law magazine, please do contact me on WhatsApp. My contact number is 98407-18196. You can also contact me through email. My email ID is lawyersocietyofficial@gmail.com. Thank you for listening. Stay tuned.